Article 84 Trust Canon 1900 A trust is a fictional form of relationship and agreement whereby certain form, rights and obligations are lawfully conveyed to the control of one or more persons as administrators for the benefit of one or more other persons. Canon 1901 All valid trusts possess the following characteristics known as the standard characteristics of trust. A trust instrument, also known as a trust deed identifying the essential form of the trust, the property to be conveyed to create the trust and how the trust shall be administered, and 2. An owner of the property or authorized person having permission to create the trust instrument and convey the form and property into the trust, and 3. A collection of property within the trust defined as the trust corpus, also trust body or body corporate, and 4. At least one administrator of the trust, also known as the trustee, who is neither the owner nor authorized person who conveyed the property into the trust, appointed in accordance with the trust instrument who is then responsible for their administration of the assets of the trust being the trust corpus also being the collection of property, and v. A separate and unique set of accounts held by the trustees, also known as a separate fund, for the recording of all administrative transactions and duties, and vi. The formalization of the rights of property conveyed into the trust into a legal title held by the trustees and one or more equitable titles permitting one or more beneficiaries lawful use of property of the trust, consistent with the trust instrument, and 7. One or more beneficiaries. Canon 1902 A trust that is deficient in possessing one or more of the standard characteristics of trust cannot be regarded as a valid trust. Canon 1903 The flesh, person or persons that administer a trust are called the trustees. Trustees hold legal title to the trust property and by the original intent and design of all trusts effectively assume the former powers and rights of the owner of the realty or property conveyed into trust without being called the owner. The trustees then owe a fiduciary duty to the beneficiaries, who are the beneficial owners of the trust property. Canon 1904 There can never be less than two parties involved in the valid creation of a trust. A person cannot be both the trustee and beneficiary, nor can the same person be both owner and trustee. No valid trust may exist where the legal title and beneficial interest are both in the same person. Canon 1905 is a custom. The traditional term used to define the owner who conveys property and rights into trust is an indication of the limits of their original rights. A settlor has limited rights not exceeding their duties of conveyor, whereas a grantor or owner typically possesses more rights. Canon 1906 When an owner of a form consents to convey a form into a trust, some or all of their limited rights of ownership are conveyed to the trustee of the new trust. Therefore, the rights administered by the trustee cannot exceed the original rights conveyed by the owner. Canon 1907 When a valid trust is formed through the form of a document, this is called the trust instrument, also known as trust deed and deed of trust. When the trust is a testamentary trust for the management of an estate, the trust instrument is also known as a deed and will or simply a will. Canon 1908 The proper structure of trust instrument is dependent upon the type of valid trust as defined by these canons. A trust instrument for a type of trust that fails to conform to these canons is not a valid instrument and any such trust is automatically null and void with any property conveyed returned to its original owners. Canon 1909 The termination of a trust is dependent upon its type, the terms of its deed and the competence and relationship of the parties seeking its dissolution in accordance with these canons. Any act of termination of a trust which is inconsistent with these canons automatically has no legal basis, nor validity. Canon 1910 A trust is created by act of a party or by an act permitted by valid statute of law in accordance with these canons. There are only three possible forms of trust as determined by the presumptions and terms of creation by its trust instrument: divine, living or deceased. Canon 1911 The highest form of trust is a divine trust also involving the highest form of rights of ownership. A divine trust is purely spiritual and divinely supernatural, formed in accordance with the sacred covenant Pactum de Singular Caelum by the divine creator, into which the form of divine spirit, energy and rights are conveyed. Therefore, a divine trust is the only possible type of trust that can hold actual form, rather than just the rights of use of form, property. Canon 1912 A living trust, also called an inter vivos trust, involves the second highest form of rights of ownership. It is distinct from a divine trust or a deceased, testamentary trust that typically exists for the duration of the lifetime of the persons or juridic persons who are the beneficiaries. There are only four valid forms of living trusts: true, superior, temporary and inferior. Canon 1913. The second highest form of trust, also involving the second highest form of rights of ownership, is a true trust, being the highest form of living trust. A true trust is formed in accordance with the sacred covenant Pactum de Singularis Caelum and the pre-existence of a divine trust in the lawful conveyance from the divine trust into the true trust, the divine rights of use known as divinity, being the highest possible form of any kind of property. Canon 1914. The third highest form of any type of trust is a superior trust, being the second highest form of living trust formed in accordance with the covenant Pactum de Singularis Caelum and the pre-existence of a true trust in the lawful conveyance into the superior trust of property in the form of realty, being the highest form of rights of use of object and concepts by divine right, also known as divinity. Canon 1915. A temporary trust is the third highest form of living trust, involving the temporary conveyance of property from one superior trust to another. Excluding negotiable instruments, a temporary trust is not permitted to exist beyond 120 days. Canon 1916. The lowest form of living trust, possessing the lowest form of rights of ownership, is called an inferior trust, also known as an inferior Roman trust, or simply Roman trust. An inferior trust is any living trust formed by inferior Roman law, claims and statutes. Canon 1917. A deceased trust, also known as a testamentary trust, also known as a deceased estate and simply estate, is the lowest form of trust and the lowest form of rights of ownership of any possible form of trust. Deceased trusts are exclusively an invention of inferior Roman law, whereby property is conveyed into a testamentary trust upon the death of the testator. Inferior Roman law has a hybrid deceased trust called a sestuicavi trust, which uses false and extraordinarily illogical presumptions to create deceased estates for the living on the presumption they are dead. Canon 1918. A person proven to have acted in fraud or breach of their fiduciary duties as trustee automatically ceases to hold the position from the time of the fraud or breach. Any liability associated with the fraud or breach of duty of a former trustee is automatically personally assumed by the disgraced former trustee. Canon 1919. Any claim that an inferior Roman trust possesses superior standing and rights of ownership compared to a superior trust, or true trust, is an absurdity against divine law, natural law and positive law, and therefore is null and void from the beginning, including any associated covenants, deeds and agreements concerning property rights and lesser trusts. Article 85. Divine Trust. Canon 1920. A divine trust is a purely spiritual trust validly registered into the Great Register and Public Record of One Heaven, containing actual spiritual form as well as divine property, administered by the Treasury of One Heaven as trustee in accordance with the sacred covenant Pactum de Singularis Caelum as sacred deed for the benefice of a divine person. Canon 1921. In accordance with these canons, a divine trust has been created and exists for every single man, woman and higher order spirit that has ever existed, or is living at this moment. Canon 1922. By definition of divine law and natural law, the divine creator is the one, true and only owner of all objects and concept. This is because, except for the divine creator, objects and concepts cannot own one another, only themselves. This also means that a fiction, such as a trust, cannot own or hold any object or concept, only another fiction. Canon 1923. A divine trust is the highest possible form of trust and unique as the only possible type of trust that can hold actual form, rather than the rights of use of form being property. Canon 1924. In accordance with these canons, a divine trust can never be terminated. Canon 1925. A divine trust is formed when a divine immortal spirit, being part of the divine, agrees with the collective divine known as unique collective awareness to be recognized as a unique member of the divine in accordance with the sacred covenant Pactum de Singularis Caelum. Into the divine trust is then placed one unit, one, representing one unique divine immortal spirit and mind, one unit, one, representing the unique energy, life experience and creation from the beginning, and one unit, one, representing all regrets, debt, mistakes, destructive acts sometimes described as sins from the beginning, collectively known as the divine form. Canon 1926. In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, a divine immortal spirit is defined as any unique collective awareness associated with the formation and existence of a specific form of matter within a level of space within the universe. Therefore the universe as a whole is a divine immortal spirit. The Milky Way galaxy is a divine immortal spirit as well as physical aggregate of matter, as is the divine immortal spirit of a member of the Homo sapiens species native to the planet Earth. Canon 1927. The divine form conveyed into a valid divine trust for a divine immortal spirit is known as the divine corpus, or divine living body representing a valid legal personality known as the divine person. Canon 1928. No form contained within a valid divine trust may be conveyed, nor any transactions or effects undertaken on behalf of the trust unless it is in accord with these canons and the Sacred Covenant Pactum de Singularis Caelum. Canon 1929. Any claimed ownership, conveyance, lien, or other fictional device over any form within a divine trust that are not in accordance with these canons is a fraud and gross injury to the divine creator and therefore automatically null and void from the beginning. Canon 1930. A divine immortal spirit may only be associated with one valid divine trust and therefore one valid divine person. Canon 1931. A divine person created for an organic higher order life form may only be associated with one flesh vessel as trustee of a valid true trust and therefore one valid true person whilst the flesh lives. Canon 1932. In accordance with these canons, every child or higher order spirit that is born from now until the end of time possesses a divine personality through the creation of their divine trust before any other legal entity or claim. Canon 1934. When a particular divine person of an organic higher order life form no longer has any valid association to a true trust and a living flesh vessel, then an association is permitted whereby 100 divine persons in similar condition come together as an aggregate to form a supreme divine trust. Canon 1935. In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, all men, women and higher order life, living and deceased are members of one heaven, therefore possessing a unique divine trust and divine personality is demonstrated and proven by the existence of a unique membership number for them. Canon 1936. As all men, woman and higher order spirits, living and deceased are automatically members of one heaven in accordance with the Sacred Covenant Pactum de Singularis Caelum, it is not necessary to give further notice to any man, woman or higher spirit of the existence of their divine trust beyond the publication of these canons in the Sacred Covenant. To this fact, Canon 1937. The divine creator is the owner of all divine trusts. Therefore, no individual spirit, person, entity or aggregate has the lawful right to demand the termination of a divine trust and a divine person. Article 86. True Trust. Canon 1938. A true trust is a form of living trust containing divine property known as divine rights of use, or divinity that is validly registered into the Great Register and public record of a global Eucadian society. A true trust may be for a single man or woman called a true person trust, a true location trust containing divine right of possession of promised land, or an aggregate trust such as a universal true trust, global true trust or civil true trust. Canon 1939. By definition, divinity or divine rights of use cannot exist without the existence of a divine trust. Therefore, no valid true trust may exist unless it is connected and created from a valid divine trust. Canon 1940. A true trust is the second highest possible form of any type of trust holding the highest possible form of any kind of property being divine rights of use known as divinity. Canon 1941. A true trust may only be associated with one valid divine trust and therefore one valid divine person. A divine person is always the owner and grantor of a valid true trust. Canon 1942. A true person trust is formed when a divine person grants certain divine rights of use, known as divinity, into the true person trust, creating the trust corpus of the true trust, also known as the true body corporate, also known as the true person, having legal personality. The flesh vessel, also known as the living flesh, also known as the living body of the organic higher order life form, is always the trustee with the true person as beneficiary. Canon 1943. When the trustee dies, the true person also dies. As a living, inter vivos trust, a true trust lawfully terminates upon the death of the person or juridic person listed as beneficiary. Canon 1944. Any property rights granted from a true trust may only be conveyed to a superior trust of the same name and no other. Canon 1945. In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, each and every living man and woman have been duly appointed trustee of a unique true trust through the conveyance of divine rights by divine personality. Article 87. Superior Trust. Canon 1946. A superior trust is a form of living trust validly registered into the Great Register and public record of a global, or national, or local Eucadian society or entity containing real property, also known as realty, being the highest form of rights of use of object and concepts administered in accordance with these canons and its sacred covenant as deeds for the benefit of a superior person. A superior trust is the third highest form of trust. Canon 1947. By definition, realty, also known as real property, is first rights of use of objects and concepts above all other claims. Therefore, real property cannot exist without some valid divine right of use, also known as divinity. Therefore, no superior trust may exist unless it is connected and created from a valid true trust, which itself must be connected and created from a valid divine trust. Canon 1948. A superior trust may only be associated with one true trust and therefore one true person. A true person is always the owner of a superior trust. Canon 1949. A superior trust is formed when a true person gives, grants and conveys certain rights of use, known as realty or real property, to a superior trust, thus creating the trust corpus of the superior trust, also known as the superior body corporate, also known as the superior person, having legal personality. The higher society to which a superior person is member is always the trustee with the superior person as beneficiary. Canon 1950. A superior trust is formed upon a true person forming an agreement by valid deed to use certain property in accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum. Certain divine rights of use, also known as divinity, are then conveyed into the superior trust for the purposes defined by the deed. Canon 1951. The superior person of a superior trust is always a living corporate body. A superior person dies when the true person that formed it also dies. Canon 1952. As a living, inter vivos trust, a superior trust lawfully terminates upon the death of the person or juridic person listed as beneficiary. Canon 1953. Any person, aggregate or entity that claims ownership of real property without demonstrating the existence of an associated true trust and divine trust in accordance with these canons defies both logic and reason, in addition to being a deliberate fraud and therefore null and void from the beginning. Article 88. Inferior Trust. Canon 1954. An inferior trust is the lowest form of living trust possessing the lowest form of rights of ownership formed by inferior law, claims and statutes inconsistent with these canons and the Sacred Covenant Pactum de Singularis Caelum. Canon 1955. Any trust that is inconsistent with these canons and the Sacred Covenant Pactum de Singularis Caelum is therefore by law an inferior trust, no matter how old, what claims are made, how many are prepared to enforce these claims or believe such claims to be true. Canon 1956. By definition, an inferior trust is inferior to a superior trust. Therefore an inferior trust can never hold real property being first right of use above all others. Therefore any such claims of superior title, real property by any inferior trust defies all norms of logic and reason and are automatically null and void from the beginning. Canon 1957. All estates formed under Roman law are by definition formed under testamentary trusts, whether or not such structure or status is acknowledged. Therefore all estates belong to inferior trusts. Canon 1958. In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, all property of all inferior trusts is ultimately subject to the control and administration of one heaven. Any trustee, executor or administrator of an inferior trust that denies this absolute fact is in gross breach of their duties and is immediately ineligible to remain in the capacity as a trustee. executor or administrator. Article 89 Supreme Trust Canon 1959 A Supreme Trust is a valid aggregate divine trust registered into the Great Register and Public Record of One Heaven whereby 100 deceased members consent to convey their divine trusts holding actual divine form and rights into a new Supreme Divine Trust. Canon 1960 A deceased member of One Heaven is a divine person no longer having use of a living flesh vessel in the form of an organic higher order being such as a Homo sapien body. Divine persons owning a living flesh vessel are not permitted to convey their form and rights into a Supreme Trust. Canon 1961 As condition and consent in being a member of One Heaven, all deceased members and the Divine Creator grant the Treasury of One Heaven the right to form a necessary number of Supreme Trusts for the benefit of the Society and all future generations of deceased and living members. Canon 1962 The total number of Supreme Trusts may not exceed the total number of deceased members as indicated by the issue of valid membership numbers divided by 100. Canon 1963 When forming a new Supreme Trust, the Treasury of One Heaven shall respect the historic relationships and connections between deceased members and major events in their history so that members are grouped together in a Supreme Trust sharing similar history, events and values. Therefore, for example, deceased leaders of a civilization or entity should by right be connected together, as should family members, as should those that died together. Canon 1964 In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, upon the formation of a new Supreme Trust, the Treasury of One Heaven is permitted to issue 1. Supreme Bill of Exchange, 1. Supreme Certificate of Equity, 1. Supreme Bond of Promise and 1. Supreme Credit Title all to the base value of 1. Canon 1965 A Supreme Bill of Exchange, also known as a Supreme Bill and simply Bill may be issued against the 100 units of debt conveyed from the Divine Trusts into the Supreme Trust. A Supreme Bill therefore represents the most perfected debt instrument above all other debt instruments with the 100 members as individual acceptors through their existence of their membership numbers on any bill of exchange instrument. Canon 1966 When monetized, a Supreme Bill of Exchange represents the most superior form of debt currency of any and all systems. The failure for any juridic person to refuse acceptance of a Supreme Bill of Exchange shall represent a most serious fraud and automatically render such a person, entity or aggregate in extreme dishonor of all laws of trade and exchange, subject to immediate sanction and penalty. Canon 1967 A Supreme Certificate of Equity, also known as a Supreme Share Certificate and Simple Share may be issued against the 100 units of actual form of spirit and mind conveyed from the Divine Trusts into the Supreme Trust. A Supreme Certificate of Equity therefore represents the most perfect and highest certificate of equity above all other forms and certificate of equity. Canon 1968 A Supreme Bond of Promise to Pay, also known as a Supreme Promissory Note, also known as simply a bond may be issued against the 100 units of energy and spiritual activity conveyed from the Divine Trusts to the Supreme Trust. A Supreme Bond of Promise to Pay therefore represents the highest form of promissory note and bond possible. Canon 1969 A Supreme Credit Title, also known as a Supreme Credit represents the full legal title held by the Treasury of One Heaven as trustees over the assets held in Supreme Trust. Because of the extreme value of a Supreme Credit, it is forbidden to sell or purchase a Supreme Credit. However, the Treasury of One Heaven is permitted to use the share and bond of a Supreme Credit as underwriting to a universal trust representing a universal gold credit, including the conveyance of the bill to the Universal Trust. Canon 1970 The holding of an authenticated abstract of a Supreme Credit does not imply in any way a transfer of ownership, nor title, nor rights, nor assets. Any person, juridic person or entity that seeks to monetize, use a Supreme Credit except for the express purpose the abstract was provided is guilty of gross fraud and dishonor, with any subsequent transaction null and void from the beginning. Article 90 Universal Trust Canon 1971 A universal trust is a valid aggregate true trust registered into the Great Register and Public Record of One Heaven or Global Eucadian Society. There are only two permitted types of universal trusts: a Universal Credit Trust and the Ucadia Universal Trust, also known as the Ucadia Trust. Canon 1972. The Ucadia Universal Trust is the complete and entire universe as one valid person representing the divine trust. Unique collective awareness in the personality of Ucadia is all of existence. As Ucadia is registered into the Great Register and Public Record of One Heaven, Ucadia is recognized as a full member of One Heaven. Canon 1973. No person, entity, aggregate or force may claim a higher trust within the dimension of the universe than the Ucadia Trust. Canon 1974. Only trustees nominated by the Treasury of One Heaven are permitted to act as trustees on behalf of the Ucadia Trust. Canon 1975. Wherever valid business or trade of any kind is engaged by the name Ucadia in association with these canons and the sacred covenant Pactum de Singularus Caelum, it shall be according to the rights and obligations of the Ucadia Trust. Canon 1976. Any inferior juridic person or inferior trust or estate that seeks to enforce a claimed control over the assets of the Ucadia Trust is in grave breach of all forms of law, and such act is immediately null and void. Canon 1977. As these canons have been promulgated and notice given, it is the responsibility of inferior juridic persons and their officers to make effective change to their records for any business or trade of any kind by the name Ucadia. Failure to correct their records is no excuse. Canon 1978. Any man or woman acting as surety to an inferior person that seeks to enforce a claimed control over the assets and direction of the Ucadia Trust or derivative thereof, automatically assumes and consents to the full liability and consequences of their actions, including the immediate loss of any legitimate right to act as trustee, executor or administrator, any subsequent charges of fraud and all penalties and punishments. Canon 1979. Any man or woman who falsely purports to represent Ucadia without valid authorization is guilty of serious fraud and automatically assumes and consents to the full liability and consequences of their actions, including the immediately loss of any legitimate right to act as trustee, executor or administrator, any subsequent charges of fraud and all penalties and punishments. Canon 1980. A Universal Credit Trust is formed by the lawful conveyance of 1/100th of the value of a supreme bill of exchange into the new Universal True Trust, including divine rights of underwriting by supreme equity and supreme bond. Canon 1981. All universal credits trusts are administered by the Globe Union Treasury in accordance with these canons in the Charter of the Globe Union and Globe Union Reserve Bank. Article 91. Global Trust. Canon 1982. A global trust is a valid aggregate true trust or superior trust registered into the Great Register and Public Record of a global Ucadian society. There are three types of global trusts: global credit trusts, global true trusts and global superior trusts. Canon 1983. A global credit trust, also known as a global silver credit trust, is formed by the Treasury of the Globe Union upon the conveyance of real property from a universal credit trust, also known as a universal gold credit, in accordance with the charters of the Globe Union and the Globe Union Reserve Bank. Canon 1984. A global true trust is formed for each global juridic person specifically named within the sacred covenant Pactum de Singularus Caelum and associated covenants and charters by its divine personality and conveyance of divine right of use, also known as divinity. Canon 1985. A global superior trust is formed by the individual covenant or charter of the global juridic person and global true trust for each of its organs and entities into which real property, or first right of use of objects and concepts by divine right are conveyed. Article 92. Civil Trust. Canon 1986. A civil trust is a valid aggregate true trust or superior trust registered into the Great Register and Public Record of a global or civil Ucadian society. A civil trust is generally for a nation, or province or community or town for the benefit of its members. An aggregate larger than a nation is usually a global trust. Canon 1987. Only one civil true trust may be formed for each civil juridic person named within the sacred pronouncements of Ucadia, the sacred covenant Pactum de Singularus Caelum and associated covenants and charters. Canon 1988. A civil superior trust is formed by the individual charter of the civil juridic person and civil true trust for each of its organs and entities into which real property, or first right of use of objects and concepts by divine right are conveyed. Article 93 Mercantile Trust Canon 1989. A mercantile trust is a valid aggregate superior trust registered into the Great Register and Public Record of a global or civil Euclidean society. A mercantile trust is generally for a trade and commerce. A mercantile trust is always a superior trust and can never be a true trust. Canon 1990. A new mercantile trust is formed when one or more true persons holding various property agree to form a new trust with specific mercantile objectives by conveying and combining these rights under deed and title. Article 94 Union Trust Canon 1991. A union trust is a valid aggregate superior trust registered into the Great Register and Public Record of a civil Euclidean society. A union trust recognizes the union between two consenting adults for the purpose of forming a singular superior person in the trade and transaction of their lives. A union trust is always a superior trust and can never be a true trust. Canon 1992. A new union trust is formed when two true persons holding property agree to form a new trust by conveying and combining these rights under deed and title. Canon 1993. The life of a union trust is the life of the union representing at least two members including children. Upon a request to terminate the trust by one or both of the founders and no children exist, the trust is terminated. However, in the event children exist, the union trust survives until the children reach majority, also known as adulthood. Article 95 Clan Trust Canon 1994. A clan trust is a valid aggregate superior trust registered into the Great Register and Public Record of a civil Euclidean society. A clan trust is always a superior trust and can never be a true trust. Canon 1995. A new clan trust is formed when two or more true persons of the same clan and blood holding property agree to form a new trust by conveying and combining these rights under deed and title. Canon 1996. The life of a clan trust is the life of the clan representing at least two or more members. Upon the clan trust only representing one member, the clan trust is terminated. Article 96 Official Trust Canon 1997. An official trust is a valid aggregate superior trust registered into the Great Register and Public Record of a global or civil Euclidean society. An official trust holds real property relating to an official position within a valid Euclidean society. An official trust is always a superior trust and can never be a true trust. Canon 1998. A new official trust is formed when a global or civil Euclidean society conveys property from a true trust representing the office and a true person conveys their property and obligations to form a new superior trust. Canon 1999. The life of an official trust is the life of a true person holding the office. Upon leaving office, the rights bestowed by the true office trust revert, including any additional property and effects. However, the release of obligations of a true person having left office is dependent upon their oath and vows. Canon 2000. The obligations and agreements acquired through office outlive the termination of the official trust by reverting to the true office trust and then conveyed to the new superior official trust of the new official. Article 97 Location Trust Canon 2001. A location trust is a valid aggregate superior trust registered into the Great Register and Public Record of a civil Euclidean society. A location trust holds real property pertaining to land and associated immovables and movables. A location trust is always a superior trust and can never be a true trust. Canon 2002. As land is physical matter within space existing in accordance with natural law, it cannot be owned by a fiction such as an owner, or trust. Therefore, in order to enable lawful ownership of land, a valid fictional form derived from the objective existence of land is required. This fiction is called location. Canon 2003. A location is a valid survey of the land and the creation of its metes and bounds so that the description is consistent with an unbroken succession of surveys from the accurate survey of divine law down to the cadastral location survey. Canon 2004. Neither trans title nor incomplete and inferior claims of survey may be used as valid arguments for succession in defining a valid location. Canon 2005. A location trust is equivalent in name only to a land trust, also known as land title. Canon 2006. A location trust is not equivalent to estate-based land title and rights, particularly real estate. Real estate is the first right of use within the estate, whereas real property is first right of use by divine right, above all other claims. Canon 2007 All land title based upon an estate and therefore testamentary trust is by logic and reason inferior to any land title based upon real property. Canon 2008 As all land title based on real estate is inferior to land title based on real property, all associated claimed liens, easements and conditions of title have no lawful or material effect. Canon 2009 A new location trust is formed when one or more true persons holding various contested or agreed rights such as ownership, occupation, possession and location agree to form a new trust by conveying and combining these rights under deed and title. The perfection of these various rights then determines the status of the title of the location trust. Canon 2010 There are only 4 types of status of a title concerning a location trust: perfect, clear, contested and provisional. Canon 2011 A perfect title for a location trust is when the true persons hold proof of right of ownership, occupies the land and a valid Eucadian society conveys right of location into the new trust perfecting title. Canon 2012 A clear title for a location trust is when the true persons hold proof of right of ownership, but do not occupy the land and a valid Eucadian society conveys right of location into the new trust clearing the title. Canon 2013 A contested title for a location trust is when the true persons occupy the land, but their proof or right of ownership is contested by another true person, therefore suspending the conveyance of the rights of location into the new trust until the controversy is resolved. Canon 2014 A provisional title for a location trust is when the true persons occupy the land, they have made improvements to the land. They claim their right of ownership through possession and abandonment or non-use by the owner. They have defined a location survey but neither the survey has been validated against all valid land titles nor has the owner not had time to lodge an objection. Thus the conveyance of the rights of location into the new trust is suspended until a period of time for the owner to object. Canon 2015 In matters of dispute, a perfect title is always superior to a clear title and a clear title is always superior to a contested title or provisional title. Canon 2016 The assertion and enforcement of a claim by an inferior juridic person through inferior estate title against a superior person and real property ownership constitutes a gross injury and fraud against the law, with no lawful form other than the rule of force. Canon 2017 Any inferior juridic person or inferior person that participates in gross fraud against the law by asserting inferior rights over lawfully superior rights accepts and consents personally to the fully liability of their actions including the pursuit of maximum punishment and penalty against them at the earliest opportunity. Article 98 Temporary Trust Canon 2018 A temporary trust is a valid trust formed for the express purpose of temporarily administering assets and property in transition from one type of permanent living trust to another, including use in negotiable instruments. Canon 2019 In accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, all forms of temporary testamentary trusts, cestuique, vi, trusts, estates and other forms of trusts for the purpose of administering the assets of a deceased estate are henceforth forbidden by all forms of valid law. Canon 2020 Instead, all valid deeds and wills of testament form a valid temporary trust not exceeding 120 days in life before the trust must be terminated and all assets and property conveyed to another form of valid permanent trust. A temporary trust may not convey any property or assets to another temporary trust for the same heirs and beneficiaries. Canon 2021 A temporary trust as part of a negotiable instrument is permitted to exist beyond 120 days when such instrument conforms to the standards of negotiable instruments of these canons.